NACDL is the association of the nation's criminal defense bar.
This project is supported by grant number 2019 YABXK001, awarded by the Bureau of Justice Assistance. The Bureau of Justice Assistance is a component of the Department of Justice's Office of Justice Programs, which also includes the Bureau of Justice Statistics, the National Institute of Justice, the Office of Juvenile Justice and Delinquency Prevention, the Office for Victims of Crimes, and the SMART Office. Points of view or opinions in this program are those of the presenters and do not necessarily represent the official position or policies of the U.S. Department of Justice.
Good afternoon. I'm going to talk with you today about this research project I've been involved in, and it's really the dilemma of the defendant with a prior record. So we're going to talk about that, and this is going to be based on a study of people who were wrongfully convicted, who were exonerated through DNA evidence. So let's start with this, the conventional wisdom. So the conventional wisdom indicates, or the CW as we sometimes call it, is if it were me and I were charged with a crime I didn't commit, I'd put my hand on the Bible, I'd get up on the witness stand, I'd look the jury dead in the eye and tell them I didn't do it. Only guilty people don't testify. That is the conventional wisdom. That is what most people believe or say. The problem with the conventional wisdom is that it's wrong. Many innocent defendants do not, in fact, testify. And the primary reason is fear of being impeached with their prior convictions. And also, when innocent defendants do testify, or when they did testify, judges always allowed them to be impeached with prior convictions, even when it was discretionary, when the judge didn't have to allow the impeachment. So let's start through and walk through a couple of different things. First, I'm going to start with a premise, which you may or may not agree with, but I hope you do, is that the rules of evidence should promote the defendant's testimony. An individual has a constitutional right to testify, but for a variety of reasons, the system should encourage defendants to testify. Because when they don't, the jury can be and is deprived of valuable information relevant to a reliable determination of the individual's guilt or innocence. So when we silence defendants with either the rules of impeachment through prior convictions or through other rules of evidence, we are creating more unreliable trials, and that is not an outcome that that is desirable and shouldn't be permitted. So let's start with another sort of legal principle here. The prosecution is not, as a general rule, permitted to present evidence of the defendant's bad character. We call this the anti-propensity rule. And the rationale for this is that the jury will overvalue the evidence and punish the defendant for crimes other than those for which he was on trial, and or convict when it is unsure of guilt, when it's really not persuaded beyond a reasonable doubt that the person is guilty, on the theory that the defendant is a bad person, that because he did X in the past, he most likely did Y, the crime that he is on trial for. And so the rules generally make this inadmissible evidence of a person's character trait for the purpose of proving action in conformity therewith on a particular occasion. That's Rule 404A. That's right. There are some exceptions to this, which are in 404B. If you're trying to show something other than propensity, motive, opportunity, identity, and other things. But this is the basic framework. So given the anti-propensity rule, permitting the prosecution to impeach a defendant with evidence of prior convictions has been, and is, and continues to be controversial because it can lead to, for reasons which should be obvious, end runs around the anti-propensity bar. Right? It wouldn't come in under 404A, but it's coming in under the rule of impeachment. And so we have this system now where character evidence is often admitted under the guise of impeachment, even when it has little to do with credibility, the credibility of the defendant. Because 609, federal 609, and every state has a rule that is almost identical to this or virtually identical to this, either in wording or in substance, generally allows impeachment under two under two circumstances. The first is if the crime involves dishonesty or false statement, then they're automatically admissible for impeachment purposes. But second, other crimes punishable by a year or more may be used to impeach the defendant if the court determines that the probative value of admitting the evidence outweighs its prejudicial effect to the accused. 609 has a few other things. There's a 10-year sort of rule. After 10 years, the presumption in the second category sort of shifts. There's a special sort of carve out for juvenile adjudications, but this is the basic framework of 609 and how it operates. There are really just a few states that don't allow it. West Virginia, Hawaii, for example, don't allow impeachment, but every state sort of does. If you look at reported decisions, which admittedly they don't tell you everything because everything's not appealed. Some people are acquitted of this, but it's a pretty good start of this. A review of reported decisions reveals that impeachment with prior convictions is widespread. Dishonesty and false statement, which are the automatically admissible category, have both been construed very broadly to include a host of offenses which you could question, do they really have anything to do with dishonesty or false statement? And the probative value prejudice to the accused balancing is routinely struck in favor of impeachment. And when I say routinely, I mean routinely, overwhelmingly. From what you see is that there wasn't an abuse of discretion or it wasn't error for the judge to find the probative value outweighed the prejudicial value to the defendant. And this is true even in cases where the prior conviction is for the same or a very similar offense as that for which the defendant is on trial. These decisions, again, from the reported decision, they're almost never reversed on appeal. Part of that's the general reluctance appellate courts have to reverse on a discretionary ruling, and because the rules really require a defendant to even raise the issue on appeal. A defendant generally has to testify, it has to be impeached. As we're going to see when we get there, they often don't testify because of the realization, either what the judge tells them he's going to allow impeachment, or just the reality is that the lawyers know that the likelihood of impeachment is quite high. So these rules are really stacked against the defendant. So what we see is if a defendant has a prior record, he's really between, or she is really between a rock and a hard place with no really good options on what to do. If they testify, they're almost certainly going to be impeached. The jury is then going to conclude he's a bad person, therefore he's lying. He's a bad person, he's done bad things, thus he's more likely to have committed the crime. He's a bad person, we're not sure he's guilty, but we'd rather convict than acquit a bad person. So these inferences, the likelihood that the jury is going to draw one of these if the person testifies and if the person is impeached with the prior is quite high. In fact, it's overwhelming. But if he doesn't testify, most jurors are going to believe he's guilty because of the conventional wisdom we discussed at the beginning of this presentation. The common sort of sense belief, the conventional wisdom belief that if it were me, I'd testify, and only guilty people, the people that have something to hide, refuse to testify. Innocent people testify. And in either instance, the jury is likely to disregard the limiting instruction, right? They might get one that says you can only consider it for the person's credibility. You can't consider it on the question of their character, but it's just, or you can't hold the fact that the defendant didn't testify against them. But we know, and there's lots of empirical evidence to suggest that these limiting instructions are quite ineffective, and people just aren't really able to do it in that manner. So I alluded to this at the beginning, but I want to try and prove this to you with some data from the wrongful conviction cases. So what I did for this was I went and looked at the trials of all the people who were subsequently exonerated by DNA evidence. Now, some percentage of them pled guilty, but most of them, pretty high percentage of them went to trial. And so asked some questions. Well, in how many of these cases, these are now people who we know went to trial, got convicted, were subsequently exonerated through DNA evidence found to not be the person who committed the offense. How many of these people actually testified on their own behalf? And the answer was not as many as you would think. 61% of the defendants testified on their own behalf. That's not that much higher than criminal defendants generally. 50%, approximately 50% of defendants testify at their trial. So the number of innocent people that testify, isn't that much higher than criminal defendants in general, which includes a lot of people who, frankly, weren't innocent. Of the defendants who did testify, 43% had prior convictions, which were potentially admissible for impeachment purposes. In every single case, the trial court permitted the prosecution to impeach the defendant. Now, some of these were mandatory, right? And the judge didn't have the discretion to exclude it, but many of them were. And in every single case, the trial court struck the balance in favor of impeachment. And so this rule matters. 91% of the defendants who didn't testify had prior convictions which could be used for impeachment purposes. And so the next research question that we tried to answer was, well, why? And so to do this, we contacted the defendants, we contacted their attorneys, we read the trial records and reviewed them, or I did, with the help of some very smart Cornell Law students who assisted in this data gathering and research project. But in 91% of the defendants who didn't testify had prior convictions, which could be used for impeachment purposes. And the overwhelming reason that we got from the defendants or their lawyers is the reason they didn't testify is they were told by their attorney who believes that, look, the judge is going to let them impeach you with this. He's going to tell them not to consider it for your character, but the jury's going to hold it against you. And it's a much smaller data set, but if you look at West Virginia and Montana, which didn't permit impeachment with prior convictions, all the wrongfully convicted defendants testified. So I think what we can conclude from this, or what I hope you have concluded from this, is that 609 discourages defendants, even innocent defendants, from testifying, and these rules matter. So, yep. So really, this is what we can draw from this, that people, they don't testify. When they do testify and they have a prior, impeachment is allowed. When impeachment is not a concern, more defendants testify. And so I think from this, we should conclude that the current regulatory system is a failure, and it contributes to the conviction of innocent defendants. So here's a few, I want to sum up here with a few sort of suggestions and proposals. The first would be to get rid of 609 altogether. And that's almost certainly not going to happen. Prosecutors nationwide are very powerful. And there was a recent attempt to try and modify Rule 609 that would significantly limit impeachment. And for the most part, U.S. attorneys and prosecutors killed it. And we're able to get that done, and it didn't get through the committee. But so if we're not, though, going to get rid of it, then the prosecution shouldn't be permitted to impeach a criminal defendant with evidence that he's previously been convicted of a crime unless the defendant has been convicted of perjury, right, lying under oath at a prior proceeding, and the court determines that the probative value of permitting impeachment outweighs the risk of prejudice to the accused, or the defendant opens the door by offering evidence of his character for truthfulness. And if he does that, then it would make sense to allow, at least under some circumstances, some impeachment. Because, again, as we've said, the current rules discourage defendants from testifying, even innocent ones. Precluding impeachment won't lead jurors to place too much weight on the defendant's testimony. There's just the reality is jurors are already predisposed to be skeptical of a defendant's testimony. And there's really no reason to believe, except in the case of perjury, that defendants with prior convictions are more likely to lie under oath than defendants with no record. And right, other forms of impeachment of the defendant's testimony, if it somehow doesn't pan out, if there's problems with it factually, those are still available to the prosecution. So a defendant or defendants in general will not get a windfall, and certainly won't get an unfair windfall from not allowing them to be impeached with their prior convictions. So that is the sum and substance of this. And thank you for watching this video. And if you have any questions about any of this or any of this data, feel free to contact me at Cornell Law School. My email address is jb94@cornell.edu. Thank you very much, and I hope you have a good rest of your day.